interest of Nevaeh Size, William Haskins, and Jalisa Haskins. We are here on a review hearing. We're conducting this through Zoom under a finding of good cause and agreement of the parties. We're live streaming, and Ms. Taylor is making our record. What do we have new?
The kids are still in their adoptive placement. The family has their home up for sale right now. They are looking to buy a 5-bedroom so that Jalisa and Nevaeh can have their own room. And so once that gets done, then they're going to move forward with the adoption. We have been seeing some behaviors out of especially William. For example, yesterday, his foster mom went to go pick him up from school for a doctor's appointment, and he was not there. So he was truant, and she has concerns that he may be smoking marijuana. She's seen some messages on his phone and is asking for a drug screen for him. Jalisa has been doing well. She still has her job at the Market Street, but she has had a couple of seizures recently due to anxiety. She has the pseudo seizure issue. Other than that, Jalisa is doing well. And then Nevaeh, also small behaviors. She was caught with her phone making TikToks in class. And so it was $75 for the for the foster mom to get the phone back. But other than that, the kids are all healthy and happy. And
okay, are you all going to drug screen him?
I would need to check with my supervisor, but I think we sure can if we need to. The foster mom would really like that.
Judge, it's typically our policy not to do that unless it's ordered by this court. So if you want to make that order, then we would do that for you.
Yeah, I'll order that he be drug screened. I mean, it's at least at a minimum we could do an oral swab on him, and without having to go through the whole taking him to a lab and doing all that. Let's start there.
Okay.
But if he's going down that path, let's get on it. And is he still actively seeing a counselor?
Yes, he is.
Okay. I mean, that's just something a counselor needs to know. And so I think that's where we start.
Okay.
Okay. And I don't really have a problem with him having to do a UA, and I don't know whether we necessarily need to go to a lab to do that, or if she can do a home kit, on him. I hate the idea of dragging a kid down to a testing lab and doing all that, at least at this point in time.
She said she'd be willing to home test him if she were allowed to do so yesterday.
That's fine. I'm good with that. We can either do an oral swab or she can home test him.
Okay.
So I think she needs to know, I think, in fairness. So okay. Where do we stand on the adoption? I mean, how far out are we? We just waiting for them to get into the new home? Is that kind of pulled up right now?
Yes.
Have we got everything else done, basically?
Yes.
Okay. I mean, are we concerned that placement could be in jeopardy on any of the kids?
I don't believe so. I spoke with the Bear caseworker, and she's not concerned.
Okay.
Once they get moved into their new home, we will have to do the adoption home study. So we're waiting on that.
Okay. All right. Well, I guess there's not much we can do about that. So hopefully that'll happen sooner rather than later. Okay, well, got anything else?
I don't.
Okay.
We are.
All right, then I'll continue the department as permanent managing conservator and continue their current placement. And we will have a subsequent review hearing on April 2nd of 2026. That'll be on a 9 o'clock docket. My hopes are that we'll be done by then. We'll have these kiddos adopted. This is just seems like it's taken a long time. So, okay. I appreciate it.
Thank you,
Thank
Judge.
y'all. This is the department versus Brenda Miskowsky. This is we're here today on a request for court-ordered services. This is actually a reset of our original setting in this matter back on September 23rd. Miss Miskowsky was present at that hearing, and when we announced the reset date, that was at her request. So we are reappearing today to move forward. She was personally served, it appears, on September 16th of 2025. I don't have her in my waiting room. She did get the link from our coordinator this morning, and also Ms. Grants indicated they sent a link to her earlier in the week. So we're going to go ahead and move forward today. We're conducting this hearing through Zoom. We're live streaming, and Ms. Taylor is making our record. All right, we'll go ahead and take announcements.
Good morning, Your Honor. Counsel Gene Graff and Alexis Valenzuela on behalf of the department. Present, ready to proceed.
You're muted, Stacy.
Sorry about that. Stacy Grant on behalf of Brenda Miskowsky. I'm ready to proceed, Judge, and I'm hopeful that she'll show up. We've sent another email.
Stacy Zavala on behalf of the children.
All right, thank you. All right, Mr. Groff, you can call your first witness.
Today's first witness, Your Honor, is Mr. Aaron Savage.
Mr. Savage, if you'll raise your right hand for me. You solemnly swear or affirm that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you, sir. You may proceed.
Thank you, Your Honor. Good morning, Mr. Savage. Who are you employed by?
I'm an investigator for the Randall County District Attorney's Office.
Okay, and what does your job as investigator entail?
So right now I'm assigned to the 251st court. So I work with the prosecutors who are assigned to that court. Most of my job is post-arrest of a criminal defendant and getting a case ready for trial. And that includes gathering witnesses, gathering extra documents, gathering anything that we need to move the case or make the case ready for trial. I also liaison with other local law enforcement and other governmental agencies to assist in their investigations.
Okay, and does that include Department of Family and Protective Services?
It does.
Okay, and did you do any investigating for DFPS in the matter of Brenda Miskowsky?
I did.
Okay, and how so?
So I was asked to research jail calls and jail visits from a Robert Alveranga, and between him and Brenda Miskowsky. He is currently in the Randall County Jail.
Okay, and how
Your
many?
Honor, may I have, I'm sorry to interrupt, Jean. May I have a brief second? She just emailed and said she doesn't have the Zoom link, so we sent it again. My apologies. Thank you, Jean.
No problem.
You need to speak with her.
Possibly we have an agreement, Your Honor, if I can get her in here.
Okay. We'll give just a couple minutes.
Okay.
Okay, we just sent it again. We've sent it again, but if you want to continue until she gets logged in, she's working on it. She's emailing us back and forth right this minute, either way. But if we have one more minute, I think we'll get her.
Judge Baker, you're muted.
I'm sorry. I'll keep watching for her. I'm gonna let him proceed. with Mr. Savage just because of our time constraints this morning, but we'll keep watching it. Maybe you can get her on by phone and just get her on speakerphone.
Yes, ma'am. We'll keep trying.
Okay. All right, Mr. Graff, go ahead.
So, Mr. Savage, you were indicating that you had been doing an investigation on behalf of DFPS, and I think that's when we had your testimony interrupted. If you could kind of pick up from there and indicate what was the nature of the investigation, please.
Yeah, no problem. So I was asked to review some jail calls and jail visits between Robert Alveranga and Brenda Miskowsky.
Okay. And how many jail visits did you review between these two?
So there was quite a few jail visits, but I only reviewed at that time the ones that were most recent to the date of my request. So I only reviewed one, but I downloaded 3 for DFPS.
Okay. Can you say how many visits, say, since May, Ms. Alveranga attended with, or excuse me, with Ms. Miskowsky attended with Mr. Alveranga?
I can tell you since the time that he was back in custody in Randall County, so from August the 11th to present date, there was 12 visits between the two of them.
Okay. When was the most recent visit that you noted?
10/7 of 2025.
Okay. And you said you observed some video recordings of the visits?
I did.
Okay. Based on those reviews, did you have any ability to form any impression about the nature of the relationship?
It appeared they were in a romantic relationship. They exchanged terms of endearment such as "I love you," and he referred to her as his boo. At one point, he tells her how beautiful he thinks she is. So these were all indications to me that they were probably in a romantic relationship.
And was these visits were they always just Ms. Miskowsky, or did
Judge, at this point, I'm going to object to it as hearsay, unless this is the proper foundation for actually submitting the evidence.
I have some documentary evidence I will be submitting. I believe counsel already has.
All right,
Yes, I don't object to the exhibits that I received in advance, Your Honor. I just feel that before we go further with questioning, it should probably be submitted.
All right, so her objection, I think, goes as to predicate foundation. So, Mr. Groff, if you want to go ahead and introduce those and then ask questions of the witness further.
Yes, Judge. I'm going to have to hold up what I have to the screen, and then I could submit electronic evidence.
Had they been circulated to everybody?
I don't know if Ms. Zavala's seen them. I know Ms. Grant, I shared them on Monday with Ms. Grant, and I can forward that right now to Ms. Zavala.
Judge, I'm sorry to interrupt, but
I have a very odd, it's not her name, but it's kind of close, so it may be her. I'm going to admit this person and see who this is.
Judge, that is her. That's the email I got from her this morning.
Okay.
Yes, ma'am. She misspells her last name and her username, unfortunately.
All right, let me make sure I've got Ms. Miskowsky. Can you hear me, ma'am? You'll have to unmute.
Yes.
All right, you have camera?
Yes.
Okay, you need to get your camera on. All right, Ms. Grant, you want to go into a breakout room with her?
Yes, please, Judge, if we could have just a brief moment.
Okay, and I just want to go back. So Mr. Groff, your exhibits that you're about to introduce, those have been circulated to all counsel, correct?
I just forwarded it to Ms. Zavala, and she was the only one, unfortunately, I left off on Monday. My oversight. Sorry, counsel.
I think Ms. Taylor. I think Ms. Taylor needs them.
Yeah, I'll forward them to Ms. Taylor as well.
She needs them, Ms. Katie. Do I have them?
I never received them, Judge.
All right.
I'll forward those right now. Sorry about that.
And Your Honor, for the ease of Jean not having to hold them up to the camera, I believe the witness has reviewed these and provided them to Jean. And so if he can just refer to them as to the Jail information previously reviewed by the witness. I don't object.
Okay, thank you.
All right. Okay, Ms. Grant, I'll get you and your client in a quick breakout room. Please, I'm sorry to cut you short, but I'm 2 minutes away from when I need to be starting my next hearing, so.
I understood.
All right.
Judge, my client will agree to cooperate, and she's prepared for you to court order today a drug screen, and she is willing to set an appointment to have her house viewed. And then I will help navigate her through whatever services or cooperation is necessary.
Okay, Ms. Grant, I heard you talking, I had stepped away. So
My apologies, Your Honor.
I missed whatever you initially
My
said.
client would like to agree to cooperate with the department today. I've prepared her for the fact that they're probably wanting a court-ordered drug screen today. She's prepared to submit to that. She's prepared to let the investigator review her home, and she's asked me to help navigate her through whatever else may come following the first two things that I knew to tell her.
Okay,
She understands about services such as parenting classes and so on, but we don't have a service plan yet, so we will navigate that together.
okay, all right.
Great.
Okay, all right, so if mother is in agreement to work services, drug test today, is the department wanting that?
Yes, ma'am.
Hair NUA?
That would be the preference, yes. And then just the standard meet with FBSS and work out a service plan, which we anticipate will involve, some counseling, maybe some drug education classes, parenting classes, kind of the standard.
Sexual abuse education classes, I think, would be
That
appropriate.
would definitely be advisable under the circumstances and due to the nature of the allegations. We would like that, yes.
All right, then, Ms. Zavala, does this work for you?
Yes, Your Honor. I do want to make sure that she knows that at some point we will be contacting her to come by and meet with the children, or we may meet with them at school as well. But yes, I am in agreement to this.
And Your Honor, if everyone would keep me closely involved and copied on emails and meetings, I'd be happy to help navigate to ensure my client's comfort.
No problem.
Right. Ms. Miskowsky, I appreciate your willingness to cooperate. I mean, these people are here really to help you and try to give you some support in a time that you may be really needing that. I'm going to tell you straight up, your continued contact with Mr. Alveranga is going to continue to raise red flags and is going to continue to cause you problems. So you need to be thinking real hard about that relationship. I don't know what else to tell you. When you've got children the age that you have and a registered sex offender is in the picture, the red flags go up in a big way. So you need to talk to your attorney about that some more and give that some thought, but I'm just telling you, that's kind of the way it is.
Yes, ma'am.
All right, then I will approve this as announced. We'll court order these services. Expect that Ms. Miskowsky will cooperate with the department, with the FBSS branch, and she will go drug test hair and UA today before 4 p.m. And that service plan will get created, but I clearly want a sex abuse awareness class to be included in that. I may not be giving it the exact right title, but I think everybody knows what I'm talking about. And then I'll see you back on a compliance hearing December 4th of 2025. and that will be on a 9 o'clock docket. So that's just kind of a check-in hearing, Ms. Miskowsky, and we'll see how things are going at that point in time, okay?
Okay.
All right. Is the baby that you're holding your baby?
Yes, ma'am.
Okay. I've got children's 5, 7, and 9 listed.
I don't have a 5-year-old. I have a 9-year-old. My 7-year-old's fixing to be 8 in a week, and I have a 1-year-old and a newborn.
Okay, Mr. Groff.
We
Ms.
show
Zavala,
William and Iris and Wyatt. Who are we missing, ma'am?
She was just born. Her name is Aurora.
And when was she born?
September 11th.
Okay. All right. All
So,
right.
Your Honor, I assume that child will not be subject to this order. At least without us amending some paperwork.
Yeah.
We'll
I mean,
likely be, we'll be amending.
Thank you.
Mhm.
So then we can agree, Judge, in advance here that the amendment will be coming and all the children will be under the same case.
Great. Thank you, counsel.
yeah. Do I have correct? What is Wyatt's date of birth?
04/04/2024.
2024. Okay. We had it as 2020, so I don't know if the department needs to check their petition. We could have data entered something just incorrectly, but everybody double check. So
And
if we're going to be amending, let's make sure we got all that correct. So
Yeah, and I know we're trying to wrap up, but since we have mom here, we have September 8th, 2016 for William. Is that accurate or inaccurate, ma'am?
Accurate.
Okay, and then Iris, we have October 20th, 2017.
Yes, sir.
Okay, great. Thank you.
I'm sorry, Judge Baker, can I get Aurora's last name?
Miskowsky. Miskowski.
Thank you, ma'am.
and just to be clear, then Aurora is living with you and the other children.
Yes, ma'am.
Okay. Right. Okay, then I'll see y'all back December 4th. This is the department versus Aubrey Yarbrough. We are here on a request for court-ordered services. We're conducting this through Zoom. We are live streaming and Ms. Taylor is making our record. All right, we'll go ahead and take announcements.
Morning, Your Honor, counsel Gene Graff and Kayla Martinez present, ready to proceed on behalf of the department.
Jerry Morales on behalf of respondent mother, Aubrey Yarbrough. She's present. We are ready.
Stacy Zavala on behalf of the child.
Okay. All right.
And Your Honor, just note for the record, Ms. Martinez just texted me. She's having issues with her camera.
Okay, that's
So
fine.
she's on, but we just can't see her.
Okay.
And
All right, then.
I'm sorry, Judge. Go ahead.
Nope. We have any announcements to make? Or are we ready to call witnesses?
It's a TFF case, Judge. We circulated an order. I haven't heard from counsel. I don't know if he needs to meet with his client or if we have an agreement. I guess I'll defer to Mr. Morales.
Judge, I did speak with Ms. Yarbrough yesterday, and I think we would need to proceed with the hearing.
Okay. All right, Mr. Groff.
I would call Kayla Martinez, Judge.
All right, Ms. Martinez, if you'll unmute for me.
Yes, Your Honor.
All right, raise your right hand, please.
Okay.
Do you solemnly swear to tell the truth today?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Ms. Martinez, who are you employed by?
Texas Department of Family and Protective Services.
Okay, and in what role?
I am an investigator.
Okay, and what does that position entail?
Once an intake is received, then I go out to the home and see if abuse or neglect has occurred.
Okay, and are you in that capacity, are you familiar with the family of Ms. Aubrey Yarbrough?
I am.
How so?
I was the investigator on the case.
Okay, and what was the reason for the department involvement?
So we received an intake on Miss Yarbrough for neglectful supervision, saying that mom was being sexually active in front of the child and there was marijuana use.
Okay. And what did you do to investigate once the case was assigned to you?
So I went out to meet with mom and the child. I also met with the boyfriend. And then the two people that were living in the home with Ms. Yarbrough.
Okay. And what did you learn about the family during the course of your investigation?
So I didn't have any concerns with the marijuana use, but once I got more information on the boyfriend, I did find out that he did have some, a criminal history that was a little concerning. Also, I learned that he was not allowed to be with any children under the age of 18 due to stipulations from his criminal history, and that he had, in fact, groped Miss Yarbrough while she was under Benadryl without her consent.
Okay. And did you discuss your concerns with Ms. Yarbrough?
I did.
Was she responsive, or how did she respond?
So initially she understood why I was concerned. But then there towards, as the case progressed, she was defending the boyfriend.
Okay. And at some point, did she agree to cooperate with services with you?
Yes, whenever we did the family team meeting, she agreed to work services.
And were there specific services that she agreed to?
To do some individual counseling and then to do the sex abuse education class.
Did you work out any kind of safety plan during that team meeting or at any other time prior to filing the case?
I'm sorry, can you reword that?
Did you work out a safety plan with the mother, either at that family team meeting or at any other time prior to filing the case?
Yes, I did a safety plan prior to the FTM, and then whenever she moved to her new home, then we renewed it.
What were the terms of the safety plan?
That she would not allow Mr. Mefford to be around Celine, and that they would not reside together.
Okay. Is there any evidence that that safety plan was not adhered to by the mother?
No.
Okay. So what was it that caused you to file a petition in this case?
So I provided the two options for her. I did tell her that she would benefit from ongoing services, and mom agreed that TFF was, beneficial for her instead of FBSS.
Okay. And how long are you able to do a safety plan?
For 30 days, and then after the 30 days, it's renewed again.
Did you have concerns that once the safety plan expired, that mother would continue to have a relationship with this individual?
I did.
Okay, and so on the basis of her relationship prior to filing and your concerns about about the lapsing of a safety plan. Is it your testimony that there is a danger to the physical health or safety of the children caused by an act or failure to act by the mother?
Yes.
And who are the children and what are their ages?
It's Celine Hatfield, and she is 2 years old.
Okay. And were there any other efforts made to provide the mother with some services that would mitigate the risk that you just testified to?
Yes.
What is that?
So I told her that, we could do some individual counseling. She said that she would go back to her previous counselor. And I did express like my concerns, how she had been groped by Mr. Mefford, and that was concerning due to his criminal history. And at that point, she was adamant about, kind of defending him and that she was okay. And then that's whenever I felt like she needed a little bit more services to assist her.
Did she deny the groping incident?
No, she showed me, there was pictures, and she did show me the bruises and all of that had occurred. But then she told me he had apologized and she had forgiven him. And then she recanted and said she was not in fact under Benadryl, that she was just tired, and that she had already given him approval to have intercourse and like touch her before, so it was a blanket yes for every time.
And she was aware of his restrictions around children under 18?
Yes.
And did you discuss that with her? And if so, what was her response?
I did, but she said that his probation officer did not have an issue with it, as long as, he was being supervised around Celine. I told her that, he did all of this while Celine was in the room. So it was concerning that, like he was still being supervised and he was still groping her.
Would there be a substantial risk of continuing danger to Celine if mother did not participate in the services that you're recommending?
Yes.
And what is the risk and why is it substantial?
I think that, Miss Yarbrough could potentially put herself back in harm's way by Mr. Mefford, and that Celine, could get hurt as well.
Is it in Celine's best interest for an order to participate at this time?
It is.
Okay. Thank you. Pass the witness.
Real quickly, Ms. Martinez, why is he prohibited from being around children under the age of 18?
He was in the juvenile detention center for, I don't know if I could say the word while we're streaming, for harming a 12-year-old sexually.
Okay. All right. Okay, Mr. Morales.
Mr. Martinez, Mr. Mefford's charge occurred when he was 14 years old. Is that correct?
That is correct.
And you state that he's not to be around kids under 18. Have you seen the requirements of his probation or his registration?
So I spoke to his probation officer, and he mentioned that the incident did happen whenever he was 14. He was in the juvenile detention center for 3 years, and if he didn't commit any crimes whenever he got out, then he would not have to register. But shortly after he was, released from the juvenile detention center, he did have an aggravated assault against his own mother. And then right now, it's kind of up in the air if he's going to have to register, and that's when the stipulations were put in place.
Okay, and the stipulations were put in place by whom?
By probation.
By juvenile probation.
That is correct.
And what are the stipulations? Is he prohibited from being around children unsupervised or altogether, or are you aware of that?
So altogether, from what I understood from probation, that he could not be with anyone under 18. So whenever Aubrey or Ms. Yarbrough told me that they told her otherwise, it was a bit concerning.
Well, you just stated yourself though that at some point probation didn't have a problem with that, right? At some point that was at least not a stipulation for him.
I don't know when the stipulations changed, but I know whenever I got the case and I called him, he said that that's what it had been since July, whenever the incident happened with his mom.
But you are aware that there was at least some point where he had no stipulation or requirement that prohibited him from being around children under 18, correct?
That was before July.
But again, you're aware that that was the case, right?
That is correct.
Okay. And did you ask probation or Miss Yarbrough when probation had a conversation with her, whether it was before or after the implementation of this his new condition?
So she said that probation told her, because she bailed him out from jail. That's what I was told. That she was the one who bailed him out after the aggravated assault charge, and then moved him in with her, in Celine. And she asked, will it be an issue, because she did know his charges, his previous charges. And probation said as long as he's not around her unsupervised. But then
Okay.
whenever I asked probation, probation said it had always been that he couldn't be with children under 18.
Okay. Now, you said that she bailed him out. My review of his criminal record shows that that's not the case. Did you review any records to see who actually had bailed him out and who signed on that bond?
I did not.
Okay. Additionally, you said this is her second safety plan. Is that correct?
Yes, the second one had to change because she had moved to a different location.
When was the first one signed? What date?
I honestly, I don't remember.
Do you have an approximation of how long it's been? Months, weeks?
So like around September. Sorry. Around September 9th, maybe.
Okay. And she moved, and upon her move, did she immediately sign that other safety plan for you?
Yeah, she let me know, and she signed the day that she moved.
So she's been continuously under a safety plan for the last month, and you indicated to Mr. Graff's question that she has not violated that safety plan or given you any concerns during the implementation of that safety plan, correct?
As far as I know, no, she hasn't violated it.
So what's your basis to think that she's going to violate it all of a sudden? Is that just based on mere speculation?
No, just of information that she has shared with me and how she feels about Mr. Mefford.
But she did separate from him, and he is out of the home, correct?
That is correct, but they still have contact with one another.
And have you verified that with Mr. Mefford?
They work together.
Okay. Are you aware that Miss Yarbrough no longer works at Dairy Queen?
No, I haven't gotten any updates.
Okay. I'll pass the witness.
Ms. Vala?
Ms. Martinez, I'm just trying to get the timeline right. You said that he spent 3 years in juvenile detention. And when was he released?
Probation said he was released this year, in the summer sometime. And then he started working at Dairy Queen. That's where he met Ms. Yarbrough.
Okay, so he was released in the summer, and
Yes.
at that point he was 17.
Yes, ma'am.
And then how long after he was released before the aggravated assault of his mother happened?
I think about a month.
Okay, and at this point he's still 17?
That is correct.
And then after the assault, where did he go?
After the assault, he went to Randall County Jail, and then after making bond, he moved in with Miss Yarbrough.
When approximately was that?
It was sometime in July. I honestly don't know how long he was in Randall.
Okay. So
The assault happened on 7/27/2025.
okay. 7/27. Is he still 17 at this time?
Yes, ma'am.
So he was incarcerated for rape for 3 years. Is that correct?
Yes, ma'am.
He was out a month and there was an aggravated assault of his mother.
That is correct.
And then from there, he moves in with Miss Yarbrough sometime in August.
Yes, ma'am.
And at that point, she has is it a 2-year-old or a 3-year-old at this point?
I believe.
Sorry, 3-year-old. No, sorry,
Yes.
2.5. Sorry,
Yes.
I can't do math. So, and she was aware of his criminal history when he moved in.
That is correct.
How old is Miss Yarbrough?
She's 24.
And how old is Mr. Mefford?
17.
So Mr. Morales made a point of these restrictions are put in place by juvenile probation.
Yes, ma'am.
Now, when he turns 18, he's no longer under juvenile probation. Is that your understanding?
That is correct.
So just because he ages out of those restrictions, does it make it any safer for him to be in a home with a young child?
No, ma'am.
Okay. And I want to talk a little bit about the terms that are being used. You've said several times groping, correct?
Correct.
Okay. So if I understand the report correctly, when Miss Yarbrough exited the bedroom, she had noticeable bruises that others could see.
That is correct.
And wasn't aware of how they had happened.
That is correct.
Your Honor, I would object as to mischaracterization. I think the testimony's been that she recanted it, said that she was aware of how it happened.
Okay. But
Well, there's been testimony that she made those statements at some point in time. She may have later recanted, but she did make those statements at one point in time. So I guess, Mrs. Duvall, just make it clear sort of at what point in time you're talking about.
okay. So at the very beginning, when those bruises first appeared, was Miss Yarbrough's statement that she had taken Benadryl and she was unaware how that bruising occurred.
That is correct.
And at some point later, she changed that and said, no, I hadn't taken Benadryl. I was just tired. I did give him consent.
That is correct.
And when she exited the bedroom with those noticeable bruises to the others in the home, where had Celine been?
She had been in the bedroom with them.
When you spoke with Mr. Medford, did he indicate that he believed that he would be moving back into the home at some point?
That is correct.
At any point, did Miss Yarbrough lead you to believe that he would be returning to the home?
Yes, because she was wishy-washy,
Okay.
adamant that me and the reporter were here to mess her life up, that she had found someone who loved her now, and I was here to ruin her life.
And in fact, she describes it as a healthy, they were trying to destroy her healthy relationship.
That is correct.
I pass the witness.
Right, Mr. Groff, anything further of this witness?
Nothing further, Your Honor. State rest.
All right, Mr. Morales?
Ms. Martinez, did Ms. Yarbrough deny having sexual intercourse in front of Celine when you confronted her about that part of the allegation?
That is correct.
Pass the witness.
Ms. Zavala, any further questions of this witness?
No further questions.
All right, state is rested. So, Mr. Morales, any witnesses to call today?
Your Honor, can I have 30 seconds with my client just to see if she wants me to call her? We spoke yesterday. I just want to make sure.
Yeah, like literally 30
Yeah,
seconds.
no, I'm not going to take more than 30 seconds.
All right, just a minute. Let me put y'all in a room. All right, Yarbrough, you're going to get a prompt to go to room 2. You can say join.
Judge, I don't know if you can hear me or if you've taken a break. Ms.
No, I'm right
Pate,
here. I'm right here.
Brandy Pate's in the waiting room, and I neglected to have her added when we started this hearing, and she was just texting me asking if she could be added now while Mr. Morales is speaking with his client.
Brandy Pate?
Yes, ma'am.
Okay, sure.
Thank you.
Your Honor, I would
Okay.
call Aubrey Yarbrough.
All right, Ms. Yarbrough, you'll need to unmute for me and raise your right hand. I can hear you. Do you solemnly swear or affirm the testimony you'll give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Yarbrough, I'm going to try to be brief. Now, when you met Mr. Mefford, were you aware of his conditions? And if you were, did he have any conditions at the time, as far as restricting him from being around children?
Well, I only knew about what he did when he was younger, about 14. I only knew about that one.
Okay.
And the condition was that he was supposed to be supervised, and his probation officer, Hernandez or Hector, there we go, said that as long as he is supervised, since she is so young, that it would be fine. And he was never left home with her, always supervised.
When did you have that conversation with his probation officer?
It was in August, after he got out of jail.
Have you ever seen any written stipulations that prevented him from being around children?
No.
Now there's allegations of you having sexual intercourse in front of your daughter Celine. What is your explanation of that allegation?
So my mom's ex-sister-in-law was sleeping on the couch, and me and him were in the room. Celine was asleep. We were watching videos, laughing, and she called us out and was saying, "Oh, y'all were loud. Y'all woke me up. What are y'all doing?" And I explained it to her. We were watching videos. Sorry, didn't know we got loud. And she called my sister venting, and that's how the sexual part came into play.
And to be clear, there was no sexual intercourse occurring in front of Celine.
No,
Okay. Where does Celine stay? Where does she sleep?
she has her own bed.
Okay. Is that in your bedroom?
Yes.
Okay. How many bedrooms are in the home?
And there were 3.
And who all lives in the home?
It was Michael, Desiree Shiplet, me, Celine, and then Max came in.
Okay. Max came in. Is that a male or female?
Max Mefford.
Oh, Max. Okay. Is Max Mefford male or female?
Male.
Okay. And who is he? How is he related, or what's his relationship to you guys?
He was my boyfriend at the time.
Oh, okay. I'm sorry. I guess it Mefford. I just knew his last name. Okay, so the other 2 individuals, what are their names again? Desiree, you said?
Michael and Desiree.
Okay. Did Michael and Desiree ever?
Is my. Oh, sorry.
Yeah, hang on a minute. Ms. Yarbrough, we're having some definite lag with your internet. I'm gonna let you turn your video off. And that may improve
Okay.
the audio.
Looks like you might be under a metal building too. I don't know if that may hurt if you're using cell service.
Oh, I'm actually hooked up to Wi-Fi.
Oh, okay.
All right, let's just try it with that video.
Thank you. Ms. Yarbrough, since your signing of the safety plan, what services have you initiated?
I started counseling. I've already finished one of the classes that I was recommended to take, which was decision making.
Do you agree with me that these classes so far have been beneficial and you feel like you do have some valuable things that you can learn?
Yes.
And you indicated to me in the past or yesterday that you do not have any plans of stopping services in the event that the judge doesn't order them. You just don't feel that they need to be ordered. Is that correct?
Yes.
And so you plan on completing your safety and your services.
I do.
And are you going to continue to abide by the safety plan?
Yes.
Okay. Are you currently dating Mr. Mefford?
No.
Okay. Do you have any plans on dating him in the future?
No.
Okay. Are you guys still talking?
It's just about my phone, but I'm about to shut off the service that I put onto his phone through my account.
Okay. Is there anything else you'd like to address with the court that I failed to question you on?
No.
I'll pass the witness, Judge.
Okay, Mr. Groff?
Just a couple of brief questions, Your Honor. Thank you. Ms. Yarbrough, are you and your daughter let me strike that. Do you believe your daughter and you were safe around Mr. Mefford because his probation officer told you that he was okay, that he wasn't in violation?
Yes.
Okay. But if the probation officer told you otherwise, then your position on that would change?
Yes, then he would have never moved in.
Okay. So, but you're not concerned about his criminal history otherwise?
So all I knew about was what he did when he was 14. And then the assault with his mom. That is all I knew about. I didn't know about anything else. And I
But
asked him about it, and he was supposed to tell me, and he never did.
But you weren't concerned about the assault on his mom. You were still in a relationship with him at that time, correct?
Yes,
Okay. And you're doing individual counseling now, is that right?
that's right.
How long have you been doing that?
Sorry, I've been with her for a while, off and on. But I just started it up again 2 weeks ago.
Okay. Is it just general individual counseling, or is it specialized counseling to address the issues that we're talking about today, about your Mr. Mefford sexual history and addressing those issues?
She's specialized.
And you, did I understand that you were in a prior relationship with a relative of Mr. Mefford's?
No.
Okay, so I maybe misunderstood one of your answers when Mr. Morales was questioning you. Okay, so I'll strike that question. All right, thank you. No further questions. Pass the witness.
All right, Ms. Zavala.
Where did you and Max meet?
At Dairy Queen.
How long did you know him before you moved him into the home with your 2.5-year-old?
Going on 2 months.
And at the time you moved him in, you knew he had been in juvenile for 3 years for rape, correct?
Yes.
You knew he had just gotten out of jail for assaulting his mother?
Yes.
And that happened during the 2 months that you knew him?
Yes.
What about that 2 months made you feel like that was a safe decision for your child?
Because my thinking of it is people do dumb things when they're young, and they also do things spur of the moment when they're angry.
Is it dangerous for your 2.5-year-old to be around someone who does dangerous things when they're angry?
Yes.
Do you understand why there would be concern about what's going on in this home?
Yes.
Do you understand why you were asked to work these services?
I do.
And you've said that you agree to work the services.
Yes.
So what is the problem with the department remaining involved while you work those services?
I guess really nothing.
You moved homes, is that correct?
Yes.
Where are you living now?
With my mom.
Were you doing the call from that home?
Yes.
Who was the gentleman who was in the background earlier in the hearing?
There's
There was
literally no guys here.
There was a man walking behind you earlier?
That was me.
My hair's up.
That was my mom. Her hair is
Okay.
up.
Okay,
It's just me,
Okay.
my mom, and my daughter here.
I pass the witness.
All right. Mr. Morales, any further questions?
No, Judge.
You rest.
Rest, Judge.
But let me ask Mr. Groff, any further questions for Ms. Yarbrough?
No, ma'am.
Okay. All right. Ms. Vala, any witnesses to call today?
No, Your Honor.
All right, Ms. Vala, do you have a recommendation to make?
Yes, Your Honor.
And I think, let me just preface this by saying Mom had agreed to a TFF case. I think we're beyond that at this point. So I think this is no longer going to go into TFF. If anything, it becomes a court-ordered service case purely and simply by virtue of the fact that she withdrew that agreement. Everybody understands that?
Yes, Your Honor.
Yeah.
Yes,
Okay.
Your Honor.
Okay,
Yes.
all right, I wanted to be real clear about that. All right, Ms. Zavala, your recommendation, go ahead.
Your Honor, I do believe it's in Celine's best interest, that mom be ordered to complete the services. She has stated that she needs them, could benefit from them, and that she intends to complete them. I do think those are needed for Celine's safety, and I do, believe they should be court ordered at this time.
All right, then. At this time, I do find that there is a likelihood of danger to the child's health, and safety and well-being. Based on what I've heard today, I'm gonna order the services, and between now and of course our next hearing, I know service plan will be prepared, but I obviously want the focus of that to be regarding sexual predators and sex abuse education. Not only for the child's well-being, but I think the mother could use some real education about that. And I'm certainly glad she's back in her mother's home. I hope that helps provide some stability. But I think just, Ms. Yarbrough, you're very young still. I don't know exactly your age. I don't have that in front of me. How old are you?
I'm 24.
Okay. The first question comes to mind is why a 24-year-old woman wants to be involved with a 17-year-old male. I think that should be something you would want to address in some counseling, quite frankly. But beyond that, I think you desperately need to recognize the signs and the dangers of who you bring into your home. I mean, not just this gentleman, but it's a little scary that you choose to move someone into your home only after knowing him for 2 months and also knowing some of his history. I think it's just sort of demonstrative that you really just need some education in this regard and maybe a little maturity about these decisions. So I think you would benefit from some of the services that the department can offer you and some of the education that they could offer you. Trust me, this is not meant to be punitive to you at all. This is intended to try to prevent you from finding yourself in this situation again. My honest opinion is that you have been a victim of some sexual assault, that you're just not quite really ready to admit or acknowledge. But I think all the way around, you and the child will benefit from some further education in this regard. So I will order, sign the order to participate in services. It will not be a TFF case. I suppose that could still be on the table if mother shifted gears and agreed to that, Mr. Morales, that it might not be too late for her to have a slot in that program. But, you know, that program is fully designed around a parent who is fully engaged and wants to participate. So, you know, I don't want to waste those resources if Ms. Yarbrough is not in that headspace, so to speak. So as it stands right now, it'll be an order to participate. I'll see you all back January 6th of 2026 on a 9 o'clock docket. All right, I appreciate it very much. Again, Ms. Yarbrough, please understand this is as much for your protection and your benefit as it is for the child's. I see some real red flags, and it concerns me for your safety as well. All right, I appreciate everybody. Thank you. See you in January. In the interest of Indiana, stop Shelton. All right, we are here today for a review hearing. We are conducting this through Zoom. We are live streaming. Ms. Taylor's making our record. All right, we'll go ahead and take announcements.
Melinda Powell for the department. The St. Francis Permanency Specialist today is Sean Ryan.
Gary Morales for respondent. Mother Laquisha Todd, she is present. We are ready.
Stacy Zavala on behalf of the children.
Brian Brown for Cameron Shelton, and I'm filling in for Vince Nowak.
All right, appreciate y'all. Okay, let's get an update on Indiana since the court report was filed. I've read the report, so I know where we were, at least up to that point in time.
Indiana is doing really well in her placement. She has her behavior significantly improved in school. So that tells me her therapies are going pretty well, her individual therapies. She does have some outbursts here and there, but it is to my understanding that she talks to her teacher about when she does need, time to step away and gather her thoughts, things like that. But overall, I would say her attitude and things like that have definitely improved in school. So that's a positive sign.
Okay. Any problems in the home for grandma?
Not at this time, no, ma'am.
Okay.
And Judge, just for the record and the court's knowledge, and Daniel's here and he can correct me if I'm wrong, I was having a conversation this morning. I know that the other case has been set for mediation. I believe there was going to be a request to go ahead and mediate this one along with the other one as well. Is that right, Daniel?
Yes, if we could do that, Your Honor, that may work out best to try to get everything taken care of on all these cases. If we could roll this case in the mediation with the other one.
And
Sure,
Judge, we are definitely unopposed. I think that, we need to take care of all three kids.
I think that's great. And I think, I guess even more importantly, I think the Court of Appeals would agree with that.
And I believe we have they got a date set for October 23rd. I believe is going to be the date for the mediation.
Okay, great. I'm glad y'all got it done that quick. That's really great. No, I'm all in favor of that. Absolutely.
Okay, and I'm not sure that Vince was on all of those emails, but we can certainly let him know that that's the plan.
Okay.
And I'm not sure that he has contact with Cameron, so I don't know what to say to those issues. It's my understanding.
Yeah, I don't think he has. I talked to Vince for a second yesterday. I didn't bring this up because I wasn't sure if we were going to do this at that time. But I will reach out to Vince later today and talk to him about it.
Okay, let's just get him looped in as quick as we can since that's going to roll around in a hurry.
Yes, ma'am.
Okay. All right, Mr. Ryan, and then anything to report with respect to parents?
New? I don't believe so.
Okay, nothing new since the court report.
Correct. Yes, ma'am.
Okay. Let me just couple quick questions. Has Dad started showing up at any more of the therapeutic visits with the child?
Since the court report was filed, I do not believe so. I talked to Beth Moss for an extended period of time last week. And
That's
she
his
did.
mother.
Oh, no, that's Beth Moss is the one that does the individual therapies with
Oh,
Cameron.
I'm sorry. Okay.
Yes, ma'am. I spoke to her and she said that they've only done 3 up to date.
Okay.
Family therapy sessions.
I just was confused because the last I knew, I think Mr. Shelton was living with his mother.
Oh yeah. No, I'm sorry. I must have misunderstood the question. He is living.
No, you didn't. I just had the name wrong. So
okay. Yes, ma'am.
All right. Have you had any other contact with him recently?
Yes, he does stay in contact with me. Cameron does. It depends. Sometimes when I do go over, there's either to his mom's house to check on him. I do it normally once a month, and there's either nobody there or he's not there. He's been there a couple of times since I've been over to his mom's house to speak with him and everything. When I've been over to his mom's house though, the most recent time, I was able to get let in this time, and she said that I was just reminding her that Cameron's visit. I believe that's on a Thursday. Cameron normally has his visits on Friday. So I had gone in there and I had told her like, hey, just a reminder that he has a visit tomorrow. It's gonna be at 9 a.m. And there was a bunch of people in that house. I don't know who they are. I wasn't able to verify that either. But I did see 2 children and I did see 2 grown adults, and then including his mother in there as well. So I'm not quite sure who lives in that home.
Well, my real issue is trying to get Mr. Nowak in contact with him.
Oh, I do have Cameron. I do have Cameron's phone number. I could pass that along to Vince or give it to Daniel to give to Vince, whichever works best.
Okay, that'd be fine. Just shoot it to both of them. That's fine. Anything we can do to help him get in touch with his client so they might have some meaningful mediation would be great.
And maybe tell Cameron to call Vince. I think that may be the issue.
Okay. All right, Mr. Morales, anything to report today?
No, Your Honor, I was actually going to inquire of Mr. Ryan, but he looks like he may be frozen. But maybe he was just really still.
No, I can hear. I was experiencing some technical difficulties. I think it's okay now though.
Mr. Ryan, did Ms. Doss recently complete a drug screen?
Yes, sir. She did on the 9th. 9/17. I apologize.
And were those results significantly lower than what they had been, and they've been gradually decreasing over the last few months?
They have the levels. Let me get the levels for you right here, sir. Give me one moment. So the levels for Laquisha were give me 1 second. I believe they were at 26. I can't find it for some reason. They were lower though, yes, sir.
Okay. I believe that's all I have, Judge. Those are my questions. And then I can give a brief update or record.
That's fine. Yeah, go ahead.
Judge, after speaking with Ms. Stotts, I'd like to utilize the time that we have between now and mediation as an almost quasi-temporary order. I know this was thrown around, and I know Ms. Zavala said that she couldn't make the recommendation yet. I don't know if that's changed. And I'm not sure exactly what's going to go on with Egypt and Arrow, other than Ms. Stotts reports to me that she was told that they are looking at placing with her mother. That being the case, if that's what we're looking at doing, I'd like to see that happen sooner rather than later. And if the court is inclined on increasing Ms. Stotts' access, I'd like to see that to give us all an opportunity to see how well, especially Indiana's going to adjust, because she's had more of the behavioral issues and stuff like that. But if Miss Stotts can be a daily presence in their lives, if she can help her mother with these kids over the next 2 weeks, I think that's going to be beneficial to figure out what we need to do in mediation instead of going into mediation blind. So we'd like the court to consider increasing her time on Indiana's case, which of course we're going to be asking for the same thing for the other two, assuming that the other two do get placed with her mother sooner rather than later. But that's all we have, Judge. She's been doing really well. Her numbers have decreased significantly, and she's awaiting anything else that she needs to do. And so that's where we're at, Judge.
And I'll get everybody's input on that. I will just tell you, Mr. Morales, my only concern, and not only concern, but a big concern about up and moving the kids is that we stand to lose a placement for those two children that they have been in for a long time, that they're adjusted and comfortable in, and not knowing what might be agreed or not agreed to at mediation, that just makes me a little nervous that we could lose what's been a long-term placement. And what if something blows up and then we got kids without placement and they could be separated, they could be, even further away than they are. I mean, there's all those what ifs. So I'm just going to go on the record that is a concern.
Well, Judge, you may not recall, but we had this.
I recall, I recall all our discussion about it.
About the kids being moved?
I recall our discussion about we would start looking at that and we would, that idea is going to get knocked around, very seriously. But I don't know what has happened since that last hearing. So I'm going to want to know what has happened. And I'm just telling you, depending on what everybody else tells me, that would be a real, I don't want to, I don't want too much, too quick a knee jerk here. And then we lose what's been, a very comfortable home for two children that we might not be able to replace. So that being said, I do want to hear where everybody is on that.
And Judge, the kids were removed from their placement and then they were put in respite care.
Right.
Okay.
But and my understanding is that they're not going to go. I understand that they're not going to go back to that prior placement. I think everybody's agreed that that's not going to happen. But they are together. I guess I had the impression maybe they were familiar with respite care before they got placed there.
I don't think so, Judge. They were with, yeah.
So maybe not.
And then they were only with respite briefly, and then they were placed again. So I mean, it's been quite a few little moves for them, and I don't know that they're really familiar with where they're at. I don't know that I would agree with that.
Okay. All right. I was thinking that, I don't know why I thought that they had some level of familiarity with that initial respite care, but that just maybe I just misunderstood. So, okay.
Judge, if I may, I think what happened, they were moved to the respite care sometime around the 1st of August.
Right.
The placement they're in now is that respite care. It was changed to a legal risk home. So they've been in this current placement for 2 months.
Okay.
Is what it is right now.
Okay. And I know there was some question about when they were actually moved, and and it's because you call it different things. It was initially respite, then it was placement. So, okay. All right. But it's, so they've had that one move, and I just, anyway, that would be a concern about doing this right before mediation. But anyway, let's just hear what everybody's got to say about it.
And Judge, I was going to say, I know we're discussing the other kids. I don't know that you officially called that.
I did not.
Case. So
I did not.
Okay.
So I'd like to let's stick with Indiana initially and get through that.
And I was gonna, you said you wanted to hear from people. I wanted to hear Mr. Ryan's opinion in regards to allowing mom in grandmother's home every day. How does St. Francis feel about that?
Well, mom, mom is still testing positive for marijuana. And it's been every month as well. So I feel like that's our concern. In terms of the visits though, she does do well in her visits with Indiana. She interacts really well with her. She seems to, parent her very well too as well. She's done a lot of things like that during supervised visits that I've caught. And but like I said, that it's been 2 years since this case has been open and we're still testing positive. So that's a concern for me.
Mr. Ryan, do you have any heartache with her being in the home when grandmother is there? I mean, it would be supervised with her just assisting grandmother.
Um, I would have to talk to our supervisors with that. My supervisor, Aaron Sessions. I'm not entirely sure. I know we have also done a visit. I watched a visit with them in the movies. We went to the movie theater the other day, and that seemed to be a success. That's not a everyday thing. It was more of a reward because Laquisha has been compliant. Aside from like the drug screen issues, but like I said, she's been respectful. She's showing up to every drug screen. So I thought, and it was something that Indiana really wanted to do, and a movie she really wanted to watch. So I felt like that was a very and plus it's outside a visit house, it's more of a normal setting. So I feel like that was a healthy thing for both of them. But I would definitely have to have clarification with that. I don't think Laquisha is a danger to her to be like around, and I'm sure that LaShonda could supervise it, but I would definitely need to clear that with somebody higher up than me.
Okay, but I don't hear you telling me that she would be, if grandmother's there and she's just over there either helping cook or get Indiana ready for an activity or, getting her ready to go to bed or whatever, that there's any danger in that situation.
If it's in LaShonda's household, I don't believe so.
Okay.
And if LaShonda's there, obviously, they're supervising it. But her being alone with Indiana, not at this time.
And I don't think anybody's talked about that yet. We've just talked about her joining in and assisting in the home. So, okay.
Yes, ma'am.
All right, Ms. Powell, any other questions?
Sorry, I lost my mouse. I couldn't get unmuted. No, Judge, I just wanted to make sure to get on the record St. Francis's feeling in regards to that request.
I actually do have a question with that. Would there be a specific time, like a time frame, like an hour or 2 hours, you know what I mean, that LaShonda would have a supervised visit? I feel like that would be a little bit more of a comfortable thing. Like for instance, Laquisha goes over from 4 to 6 to LaShonda's house to help out with whatever, or in the morning, whatever the case may be. I feel like if there's a time frame that we know that she's doing that, I feel like that would be another productive for us as well.
That would be my preference, at least initially, just, and also out of respect for grandmother and her schedule. I'm not suggesting something where mom just pops in at will. I think I think a scheduled time and I don't, if grandmother needs some help, like a certain morning of the week or something like that, it's fine if she could go in the morning and otherwise maybe go in the evening. I don't have a problem with there being some flexibility with grandmother's schedule, but I think it should be a somewhat designated block of time at this point.
I guess I do have a follow-up question based on that. Mr. Ryan, have you ever had a conversation with grandmother regarding whether she would be willing for Miss Stotts to come into the home on a regular basis?
I have not.
And Judge, I mean, I know I can't provide testimony, but she came into my office and she wants that. She would enjoy the help and the time with Miss Stotts. She respects the rules and the boundaries, and I don't think that's been a problem at all. But she also supports her daughter, and she has no problems with her being there. I can represent that to the court.
Okay. All right. Okay, so let's.
mother is
Yeah, hang on just a second, Ms. Stotts. I'm gonna get to you. Just give me just a second. Okay, so anything else, Mr. Ryan, as far as updates?
No, ma'am, I don't believe so.
Okay. All right, Mr. Morales, then you and your client.
Your Honor, I don't have anything on my end. I think Ms. Stoss wanted to address something, so I'll just take that in whatever order you'd like.
Okay, Ms. Stotts, go ahead.
Oh, I was just letting y'all know that my mother was present if y'all had any questions regarding her stand on me being in the house for whatever time.
Is it any different than what Mr. Morales just told us?
No.
Okay. All right. So if we go that direction, then Mr. Ryan can work out those details with your mom and you know, we can figure out how, you know, how that best works for everybody. Okay. All right. Then Ms. Morales, anything additional today?
No,
Obviously,
Judge.
obviously no, but we'll take up the other kids here in a minute.
Yeah, nothing additional, Judge.
Okay. All right, Mr. Brown.
Yes, Judge, sorry.
Anything today on behalf of Mr. Shelton?
I've got these notes here. I don't think there's anything else to add that's not duplicative. It's just he, as we've already said, he needs to get in touch with his client needs to get in touch with him. That's the only thing you want to be get across.
Okay, yeah, we really need him to join in and participate in this because I think this mediation potentially could come out with some really, you know, important resolutions for the family. All right, Ms. Zavala.
Your Honor, I met with Indiana at her new school. Before I met with Indiana, I spoke with the school. They report her doing very well, a marked difference from the previous school year. So I was really encouraged. I understand that grandmother has moved. If Mr. Ryan can just verify that address, I did get an address from Indiana. But she is doing very well. And at this point, I don't have concerns. I do agree that grandmother's position, when I have spoken with her in the past, and it's been a while, but has been very consistent with what Mr. Morales shared. I don't, at this point, have concerns with mom having additional visits with Indiana as supervised by grandmother. I do think it would be good for everybody to have some sort of schedule and guidelines and to know what that looks like. But at this point, I don't believe that would be harmful to Indiana.
Okay. Okay, and Ms. Stotts, I just want to make clear as, you know, as long as Indiana's living in your mom's home, remember mom's rules are the ultimate rules. You know, so if your mother says bedtime is at 8:30 or 9 o'clock, that's when her bedtime is. You know, I know you're her mother, but right now she's living in your mother's home, and as long as she's in your mother's home, placed with your mom, your mother's rules trump. Okay.
Right, of course.
Okay. All right.
And Judge, we probably need to go ahead and get an order for mediation on this one as well.
Yeah, I'll have Miss Katie do the order.
Okay.
She may have already done it while we're been in this hearing, but I'll make sure she does the order in this case as well.
Great, thank you, Judge.
So, yeah. Okay, then I'm going to continue the department as permanent managing conservator of the child. I will continue her placement. I'm going to let Mr. Brown, Mr. Ryan, work out kind of a new contact schedule so that mom can be over at grandmother's house supervised for, say, you know, a couple of hours. You know, I think several days a week would be appropriate. And you know, if y'all work it out where it's a daily thing, I'm okay with that too. But the object is to help out grandma. So, so we're gonna just say we'll increase mother's visits in grandmother's home. You know, as that is scheduled. And our next review hearing in this is scheduled for April 2nd. Obviously, I'm going to order y'all to go to mediation, and that was on the 23rd of October. With the sibling case. All right. Okay, we will jump over to Arrow and Egypt's case. Mr. Brown, you're free to go because Mr. Nowak was not involved with the other kids' case. Thank you very much for your patience and for sitting in today.
Sure.
I really appreciate it. My apologies that we are running behind.
It happens. Thank you.
All right. Cause number 98234E in the interest of Arrow and Egypt Aguilar. Stotts Aguilar, we're here for a review hearing. We're conducting it through Zoom. We're live streaming. Ms. Taylor's making our record. I'll go ahead and let you all make announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Sean Rhines, my privacy specialist. We're present, ready, Your Honor.
Gary Morales for respondent mother Laquisha Stott. She is present. We are ready.
Stacy Zavala on behalf of the girls.
All right, thank y'all. Okay, what do we have since our court report was filed?
Nothing, just that the kids are doing well in placement. They're thriving. They did change placement. There was like I said, they went to that respite on 9/9. But that's about it.
Okay, they actually went in August for respite care, but were placed
Yes,
in
sorry.
the
I
same
should have
home.
clarified.
That's okay. Just, this has been a point of confusion, so they then
Yes,
were placed in September. Okay, all right. Okay,
And Your Honor, just to update everybody on where we stand, I know after the hearing we had a week or so ago, my clients are going to look at going back into grandmother's home, doing an addendum to the original home study that was done on grandmother's home. We're going to do that in an effort to see about possibly moving the children and getting all three children in grandmother's home. We're working toward that direction, and then we will have discussions at mediation about where to go from there and see what we can work out at that point.
so the answer is that St. Francis is not ready to move the children at this point in time.
Not yet, Your Honor. That's correct. Not just yet. The original home study was done. It was denied. The court actually placed Indiana back in the home with grandmother. We did not place the other two children. So in order for us, my clients to, be able to go that route, we need to do an addendum to check the home, make sure that she can handle the three children in the home right now. Mr. Ryan did speak to grandmother yesterday. My understanding from that conversation is she is willing to take in all three children and to have them in the home. We just have to go through the steps to see if we can get there.
And Your Honor, just to be upfront while we're discussing this, I've got some issues with the kids that I think they need to be addressed in that calculation as well.
Okay. So how quickly can that happen?
We're hoping to get the person that does the addendums and the home studies in hopefully by the end of the week, in the next day or two, to try to start working on that is what we're trying to do.
And in fact, I think I heard she's moved since that original home study was done.
I heard Ms. Zavala say that. Is that correct, Mr. Ryan?
She has moved, yes, sir.
Okay.
Okay.
So that will be looking at the new home and adding in to that move, yeah.
Okay. But we can have it done and up the chain or
Yes, ma'am.
something
During our
before.
meeting yesterday, they reached out to the lady that does that, asked her if she could try to get in by the end of the week to get that done. It may, it was short notice, so it may be first of next week, but as soon as she can get in, she'll get in and try to get that done.
And Your Honor, there's some assessments that are pending on Egypt that I think need to be done before a move be made. I think we're looking at the same long-term goal, but I do want to make sure that's out there, that there are some things that I believe still need to be done where she is for just a bit.
All right, Ms. Val, go ahead and just outline what you know or what the concerns
okay.
you know about or the issues you know about.
So Egypt is only 3, but throughout this case, when the girls were placed together, we had to do multiple splits at different points because of the behavior altogether. As we heard, Indiana's behavior has significantly improved. Egypt is having tantrums that last from 15 minutes to an hour, multiple 3 to 4 times a day. However, she's just started school and that's really helping. She's also been scheduled for an assessment, and I was a little unclear as to whether that assessment has now occurred and they're just waiting for the results. But in terms of behavior intervention, as of last week, she only had 2 incidents in the week, which was a huge improvement. The big issue with all of them seems to be around sharing attention, sharing things, and just these outsized reactions. So absolutely, I think we need to be looking at a long-term goal of grandmother. But if we've got these assessments going on, I think we need to finish that process. And it sounds like it's already in process. And that we get it, if and when we're looking at a move, that we get those things set up for Egypt so that she could jump right into that. Structure is really helping. Designated rules, schedules, separation of the kids to give them some time to themselves. There is another child in that home right now. So all of these are fixable type things, and all of these are things that we can work on with grandmother. So I am not saying that they should not be moved because of that. I just think we need to make sure we've got all of the paperwork, anything that we need, so that if and when we move them, that we've got that structure laid out for all the girls and we've got those behavior services for them.
All right, so let me just ask this question because of issues that have come up before, not in this case, but others. How seamless can we actually make that? I mean, if we intend and we know if we intend to move the kids, I mean, how fast can we set up providers and make sure we've got those services ready to go and hit the ground running? Because what I've heard before is, oh, well, the kids have to be here and they have to, we have to have official placement and we have to have all this. Who wants to be on the hot seat?
Well, I was supposed to say, I guess it depends, Judge, on what recommendations and services come out of these assessments that they're doing. I think is going to be the main thing. Depends on what that recommendation is and what type of service it is on the provider and how quick the provider can get it set up once we get it. I think is our main thing there.
Well, I assume, are they seeing a behavioral therapist, Ms. Zavala?
It's my understanding, and all of this information just came from placement, that there was an assessment, at least part of that assessment took place about 2 weeks ago. And that they are doing therapy. I mean, Egypt's doing some therapy. So I'm a little unclear in terms of what's left. So it may be that we just need the report from that. It may be that there's additional assessment needed. But I would think the report would help us structure a plan for when they come home. What can we, what services do we need? Can we, set out a schedule so that they've got some individual time, because it is the sharing kind of issue that seems to lead to these crazy meltdowns, the same type of ones that Indiana used to have. So it's all, we just need to determine where in the process that assessment is. And I would have to believe that those services are available here once we've got the information on what they think is recommended for them.
Go ahead, Mr. Ryan.
I can also follow up with the placement and see what can be done or what needs to be done still left, and what recommendations need to be done. I can also look into if there is recommendations, what they can do here as well. So I think that's how I would address that. Because we do offer a lot of things here as well. So I feel like that can be something that can not be transferred over here. But I mean, like I said, if there's recommendations on what they need, I'm pretty sure we can find that.
Mr. Ryan, do you know where they are in that stage? I know Ms. Zavala said there was a assessment that was done a couple of weeks ago. Have you seen
Yeah.
it? Do you know where
Yes,
we are?
sir. Well, I have not from placement yet. I know she did do her cans, and she was also seeing a behavior specialist through ECI when she lived in Lubbock, but that those were no longer needed. So I would definitely, like I said, need to follow up with placement and see what they're referring to as well.
Okay. Can you give them a call when we get out of this hearing today?
Yes, sir. Absolutely.
All right. And let me know where we stand and what we're looking at.
Yes, sir.
Go.
Okay. I mean, yeah, I think we need to know what those assessments are, and it'd be great not to have to repeat all that and just be able to get them into what they need. So all right, Mr. Morales.
Yes, Judge. And just I had to be repetitive, but just so I can make a record. As indicated in Indiana's hearing just before this, Ms. Stott's drug screen levels have significantly reduced. Her mother is willing to take in all three children, and Miss Stotts is willing to help her mother out on a daily basis. Her mother's indicated to me that she is willing and looking forward to Miss Stotts' help. And in terms of the kids, Judge, of course, Ms. Stotts would like them with her mother as soon as possible. I don't think we disagree with the fact that if there is an assessment pending, we don't need to restart that. If we could hit the ground running with some services, that would be great. On the same token, though, we don't want to be left, just kind of in limbo, knowing that the time frames on this matter are a little bit shorter than a regular deal. And so, and again, Judge, we would like, and this may be really hard depending on what we're waiting on, but we would like maybe a little bit of time prior to mediation just to see how the kids are adjusting. I think that's going to help the department more than us. I mean, that could backfire on us in mediation if the kids aren't adjusting well. But I think moving them ahead of time would be helpful in mediation just to see what works best moving forward.
Okay. All right. Ms. Zavala, anything to add?
I understand Mr. Morales's point, and that makes a lot of sense. But at this point, that gives us very little time to do that. And I am not sure that as a practical matter, we could have them back before the 23rd. But I understand where he's coming from. If we're gonna move these girls and that's where we're headed, I want to do it in a way that's not rushed, that gives a real chance at success. And I feel like we can do that. I feel like there are ways to do that. I just don't want to, like, for example, if we could get Egypt in pre-K, I think that would make a huge difference, because that's her own time, her own deal. It gives her something special to do during that. Like, if we could set that up, I think that would help. Because it has helped so far and limited her tantrums just recently. So I don't think we're that far away. I just don't know how practical it is to have that happen in just a matter of days. But maybe we can.
Mr.
I'll try.
Ryan,
Yeah, I'm sorry. I'll try to definitely get back to Daniel by the end of the day, with an answer, with in regards to the girls, that are in their current placement, what they need, what's going on, things like that. So, I'll have an answer by the end of the day for Daniel for sure.
okay, so here's how I see this. So Ms. Stotts, I mean, we're gonna initiate a big change with Indiana with the increased time that you're gonna be in the home with her. I want Indiana to have time to adjust to that. You know, she's doing really well right now. I mean, she's doing better right now than she has the entire pendency of this thing, you know, as far as her behaviors and how she's doing in school. You know, I don't want to just send her, you know, into orbit with the other kids just, you know, being rushed into the house. I want her to get kind of used to you being there more and her being adjusted to that. She's the big sister, you know, and so when the other kids come home, you know, there is always going to be some follow by example with the oldest sibling in the house. And, you know, if she's comfortable and she's adjusted to you being around and thinks, you know, the wheels are turning smoothly, I think we'll have an easier time of it with the younger children. We're getting some, I'm going to mute you, Ms. Stotts, just because I've got some background noise coming. Sound like maybe your mom's on the phone or something. I don't know. Anyway, I'm not going to rush to bring the kids home before mediation. I mean, I want to get the assessments. We want to know what we need to have set up. And then let's give it that time for, let's get Indiana used to the new program. Y'all can mediate, you know, part of your mediation, I mean, you know, could be that this is going to be worked in over some period of time. I mean, I'm not telling you what it's going to be. I'm just saying it could be, but we've got until December 9th to make a successful transition. I think everybody agrees this is where we're headed. You know, we're headed to bringing Egypt and Arrow back in place with your mom and increasing your participation with them and all of that. So let's, you know, my feeling is like Ms. Zavala, let's do it successfully, you know, and I just think putting the brakes on a little bit isn't a bad thing. I'm not saying for a long period of time. I do think it needs to happen, but I want everything in place before that happens. And I also really want to see how, you know, how Indiana's handling things. Because, you know, if she's goes back to being disruptive and having issues and, you know, that is going to most definitely impact what happens when the younger ones come home. It just does, you know, that's just the dynamics. So, let's take advantage of this little bit of time that we've got. So, Mr. Ryan, I know there's a lot on your plate, but I want y'all to talk with grandmother and mom and you know, come up with a plan for mom as quick as we can for her to start that
Yes,
being
ma'am.
in the home more, you know, like as quick as we can.
Yes, ma'am.
So, okay. All right, then. So with Egypt and Arrow, I'll continue the department as permanent managing conservator, and I will continue their current placement. We all know where we're headed. You don't have to have necessarily, you know, my go ahead to bring the kiddos home once we get everything in place. If everybody's in agreement about it, I'm good with that. Because I won't see you guys until December unless, you know, somebody calls up here and says, hey, we need another hearing, and we can do that if we need to. So You know, I'm kicking that to all of you unless you need me. And if you need to rope me in, then you know where to find me. So, okay. Anybody got any questions?
I've got one real quick, Judge. I wanted to pull something up before I ask it, just to make sure sorry, I'm trying to find the report, Your Honor.
And Ms. Stotts, thank you for the drug screen levels coming down. I hope that continues.
Yes, ma'am.
Okay. I congratulate you on that. It's a good trend.
Do I ask my question?
Sorry, Judge.
I have a question, Your Honor.
Yes, ma'am.
Oh. So I'm confused as to, okay, so I know that with Indiana, I'm gonna be able to be more present in the home, but with Ethan Arrow, when they
You're breaking
come
up.
to my
Yeah,
mom,
she's cutting
will
out.
it still be
Yeah.
the same?
Okay, Ms. Stotts, I
Like
think I know what you're
visits will be the same, and it
Ms.
will
Stotts,
apply to all three of them.
okay, you are breaking
Am
up
I
real
still?
bad.
Can you hear me now?
Okay, you're breaking up real badly. Can you turn your camera off?
You're cutting out too.
Okay. I think what you're asking me is, will this be the same once when the young kids come home, will you get to be in the home like you are with Indiana? Is that right?
Yes, ma'am. That's my question.
Yeah. Yes, that's my intent. Absolutely.
Okay. Okay. That I just wanted to clarify that so that
Yeah.
way there was no
No.
confusion.
No, that's my intent. So, all right, Mr. Trout.
Yes, Your Honor. On when you announced a second ago, I believe you stated PMC of the children would continue on the Aguilar case. Looking at the appellate court's decision, they do mention issuance of any temporary orders concerning. Did this case go back to a temporary, or are
You
we
know,
at PMC? I just want to be clear on what type of order I'm gonna do.
I don't have the opinion in front of me, but did it, I mean, it didn't overturn the PMC.
Well, so that was kind of my confusion on it, John. So I'm looking at the conclusion right
but
now.
It remanded it, correct?
Yes, ma'am. The conclusion states, order terminating LS's parental rights of her two younger children is reversed and the cause is remanded for a new trial, including issuance of any temporary orders concerning conservatorship, support, and possession access to the children.
So that needs to be a TMC order.
Okay, all right.
Yep. Yep.
That's what I thought. I just wanted to make sure.
Yep. TMC order on that case.
Okay.
And Judge, Daniel and I had this discussion, and he didn't raise this issue. That would make father's termination an interlocutory order. Would you agree with that?
And it just says the remainder of the order affecting the parental rights of AA, the father who did not appeal, remains undisturbed.
Right.
So is that a final order to him, or is it interlocutory to him right now?
I think it's a final order as to him.
Okay. Okay.
So I guess the question would be, how would that be drafted in regards to like a temporary order? Or that, like, in regards to the review order. I also talked to Kim and she was like, she had no idea how to draft this order either.
All right, hang on. I didn't terminate on Shelton.
Correct.
No, I was in regards to the father on Aguilar.
Yeah.
Okay, all right. I don't think, I mean, I think he's just out of it. I mean, it's a final order as to him. He just isn't a named party anymore in that
In the new-
case.
in
In
the new
Arrow and
Keating
Egypt's
case.
case, he's done.
Okay.
So keep that order final, and just these temporary orders will have him as terminated and
Yeah.
new temporary orders with, okay.
Yeah. Yeah. Sorry, I guess I misunderstood the question. So yeah. I'm sorry, y'all. I'm looking forward, pressing forward, trying to figure out how I'm gonna be in Carson County when I'm supposed to be there. So
I understand, Johnny.
okay. All right. Okay, then I'll see y'all back. Ms. Katie will do a mediation order in the Stott Shelton case if she hadn't already, and then good luck to y'all on the 23rd, and then I'll see everybody back in the Aguilar case. We are set for trial, of course, December 9th of 2025 at 10 o'clock.
Yes, ma'am.
Okay. All right. Thank y'all.
Thank you.
Thank you, Judge.
Interest of Michael Downey and Jay Downey Jr. We are here today on a review hearing for Michael. We're here on a review of young adult on Jay's case. My understanding is that Jay has agreed to everything in his case. And I don't know whether we've got an agreed order in that case, or do we need to take it up?
We
Your Honor,
circulated one. I'm sorry, Stacy, go ahead.
I signed off on that order. I've had no contact from Jay, and unless anything's changed that I'm unaware of, it's my understanding that he has left care. So I went ahead and signed that after reviewing that. I don't anticipate him being here.
Yeah, I'm not aware of any contested issues. We did circulate an order, but we didn't get all the signatures back in time for the hearing. So I don't know if the court would like an update from Mr. Koval, but.
And Judge, if I may, we did send the agreed order on Jay Downey's case for the extended foster care. We just don't have the parent signatures on Michael Downey's case.
Right. So we're just talking about Jay right now. So from looking at the report, I guess I thought there was going to be some discussion about should we terminate jurisdiction since he'd left care and it's been over a year.
I mean, I don't see why we shouldn't under those circumstances. Mr. Koval, do you have an opinion on that?
I don't have an opinion on that, Mr. Graff. I haven't been involved in Jay's case since he turned 18.
I just have some communication that I'd like to add.
Yes, sir.
I'm the biological grandfather and adoptive parent for Jay Downey. Currently, I'll try to make a long story short. He's had some difficulties in his life. A previous foster placement in Michigan, he was abused as a young boy. I've been working with the attorneys up there that are trying and get this case resolved where the people that were charged with this abuse will be held accountable. Jay is currently in Lubbock County for 2 counts of possession charges under a gram, 1 of methamphetamine, 1 of marijuana. He got out on PR bond and got rearrested for unauthorized camping and was taken back in for not staying in communication with his PR bond. So currently he's at Lubbock County, will probably be bench warranted up to Michigan to hopefully provide witness statements on behalf of the case that's been going on up there during his time. And I've communicated with him some. I would like to be optimistic and hopeful that Jay will make a turn in his life and get his life together and come back into care. But that's to be determined by his choices. But I just want to bring to the court's attention that Jay is a troubled young man because of the things that took place in his past. Although he's an adult now and has the opportunity to make better choices, but I would like to encourage this group to consider some extensive counseling for him or something if he would, submit to that. because for any young man to be 18, 19 years old that would rather live on the street and beg or steal or, you know, to live the life that he's been doing by choice, there's something wrong with him psychologically. And I think he's got some trauma that it needs to be dealt with. But again, if we could extend benefits or leave that open at this point, I would appreciate it on his behalf, because I feel like that he's still a worthy candidate to try to help him get his life together.
Mr. Downey, I appreciate that. And, you know, I always think, I mean, of course, I still think of them as our kids, you know, because it's just kind of the way we all think of them. But, you know, I'm happy to leave and extend the jurisdiction and leave this open for Jay. I mean, if we close it, he does have the right to come back in, you know, for a certain period of time, but I don't have a problem leaving it open and having a review again in 6 months and kind of see where we're at. You know, I'm fine with that.
Okay.
So I doubt anybody here has any heartache over doing that. So we'd like nothing better than for him to come back into care where we could get him back into therapy, counseling, treatment, whatever he needs. You know, we would, you know, we'd all be thrilled if that would happen.
Yeah, much appreciated.
I'll just say, coming down from the Portland area, Mr. Downey, there's an epidemic of kids in that same situation here and there, and it's really tragic. But I certainly appreciate your position. We won't get in the way of that.
Thank you.
Okay, so with Jay, we'll just leave everything open and we'll just extend jurisdiction on him as a young adult. He's 19 at this point in time, so we've got a little more time. So, okay, then shifting gears, we will talk about Michael, who's doing great.
He is doing great, Judge. The court report, I think, speaks for itself. No issues with Michael. He's a great student, sophomore in high school, going to be on the wrestling team again for the second year, and no disciplinary issues. He makes nearly all A's, and he's a great kid. He's a joy to have on my caseload.
Okay. And Ms. Zavala?
I agree to all of that, and actually we had scheduled 2 or 3 different meetings with him, Zoom meetings, and had to cancel all of them because he's so active. I mean, it was a good cancel. I mean, he had stuff he was doing. The report from placement is great. I have left my contact information so that he can reach out to me if he needs anything. But it's in line with every other conversation I've had with him recently, you know. So although I did not speak to him right before this hearing, all reports are really good, and he's got my contact information if he needs anything.
Okay. He's blowing and going, and so that's great. Mr. Downey, anything you want to add as far as Michael's concerned?
Yes, I mean, I would just concur that he is a great kid. He is one of the grandkids that I adopted, me and my wife, and he does bring light to the darkness that tries to surround us a lot in life. So we take a lot of joy in his achievements for sure. And my wife and I support him, you know, monetarily and help him, and would like to see him more. But obviously the distance from where we are in Amarillo to Houston's, you have to do some pretty good scheduling to make that happen. So we're hoping to see him around the holidays like we typically do for a week or so. I appreciate everybody's efforts on his behalf, and he is doing well.
All right. Then talk about Jay. I'll sign the order extending there. And then on Michael, we're going to continue the department as permanent managing conservator, and we'll continue his current placement. And I'll see everybody back. Review hearings April 2nd of 2026. That'll be on a 9 o'clock docket.
Great. Thank you, Judge.
Mr. Downey, I apologize waiting so long. We had some really kind of contested things this morning we weren't anticipating, so I'm so sorry that we had to keep you waiting this long, and I appreciate your
Understood.
patience.
Yeah, understood. There's no problem. I just wanted to speak on Jay's behalf because when nobody knows anything about him, it makes you not, aware of what possibilities there still is. And I still have, believe in the Lord and believe in Jay. Just a matter of, I hope it happens in my lifetime and he doesn't keep dragging this out. But thanks for your understanding.
You bet. We want success for him. We absolutely do.
Thank you, Judge.
All right. Thank you, sir. You have a good rest of your day.
Y'all as well.
Judge, I show the Sheffield final at 1:30, but in light of the delays, do you have an idea about approximately what time I should expect that might be called? If you do, and if you don't, that's fine too.
Let me look here real quick. Hang on. I got to trigger my light. My light's turned off on me and there. It's very annoying. We've got 2 matters to wrap up here in Potter County. I don't think either should take Ms. Zavala indicated the De Leon, that'll be, not De Leon, Via Ramos will be very quick. And I think we're just announcing MSA in the De Leon case.
Correct, John.
Y'all think I'll be done by 12:30 here with you all?
I absolutely hope so, Your Honor.
Okay. I'll leave after that immediately. I'm going to go to Carson County, which is of course part of the same district, judicial district as Hall. I know it's a Hall County case, but I'm going to Carson because that's closest.
Sure.
And so I've got, say 30 minutes to over there. I very well may make it at 1:30.
Okay.
Yeah,
I'll plan to log back in then.
Yeah, I'd say plan to log back in. I may just, Miss Katie will shoot out an email if I'm going to be 5-10 minutes late, but I can grab something to eat on the road and be headed that way. So,
and I can bring everyone in case you guys need to talk before everything gets started.
Okay. I'm expecting our hearing will just be pro forma, but I just wanted to, I just knew that my first couple of hearings this morning set us back a ways. So I just wanted to give Judge time to breathe and do what she needs to do. So
not your fault. I'll just tell you, I think from now on, if we have a TFF fall apart like that, we may just reset it, if we can.
Yeah, that makes sense.
And I thought about it this morning, but I thought maybe we could get through it and, but it's nobody's fault. It's just the way it is. So, but I think I can, since I'm only going over to Panhandle, I think I can get there really close to 1:30.
Okay. Well, drive safe and I'll see you back at 1:30, Judge.
Okay. All right.
Thank you.
Thank you. In the interest of Lucas De Leon, we're here today set for our final in this case. We're conducting this through Zoom under a finding of good cause and agreement of the parties. We are live streaming and Ms. Taylor is making our record. All right, we'll go ahead and take announcements.
Daniel Trial for the Texas Department of Family and Protective Services. We're present ready, Your Honor.
Sorry, Tracy Riley, and I'm appearing on behalf of the father in this case. We're both present and ready.
Stacy Zavala on behalf of Lucas.
Okay, Mr. Nowak is not present today. He had a conflict, but he's indicated he was fine with us moving forward since this was going to be pretty much an announcement. Ms. Riley, you were breaking up pretty badly. We'll see. You may need to turn your video off.
Is this better now, Judge?
It's better right now. Yeah.
Okay, yeah. I think I had gotten into my car and I apologize. I think that the connection was bad. But do you need me to restate my announcement?
No, we got you.
Okay, great. Thank you.
Okay. All right, then. Mr. Trout, my understanding is that the parties attended and successfully mediated an agreement. We've got an MSA. And so if you want to go through that, the high points of that MSA or introduce it as an exhibit, I'm not sure what you're going to do, but you may proceed.
Judge, what I would do, I will go through the high points on it. I would ask the court This was filed with the court on September 10th of 2025 as the mediated settlement agreement that had been signed by all parties. I would just ask the court to take judicial notice on that. I'll go through the high points, and we'll be asking the court to adopt the MSA for the final order.
All right, counsel, any objection to me taking judicial notice of that?
No objection.
No objection, Your Honor.
All right, then I will take judicial notice of the contents of the mediated settlement agreement that's been filed. And I'll allow Mr. Trout to announce the kind of the high points of that. And then assuming everything's good, then I'll adopt it. That we'll wait. I'll wait to say that till we hear everything.
Yes, ma'am, Your Honor. As part of the agreement, Mr. De Leon would be named as the sole managing conservator of Lucas. Twino would be the possessory conservator. There are some drug testing guidelines that are put in. Twee would have to submit to a 10-panel hair follicle at a facility located in Texas prior to any of the step-up visitations or visitations beginning. The results must be provided to Mr. De Leon prior to the first visit of each of the phase. The cost will be bared by Twee if for any reason she does not submit to the hair follicle test results positive in any illegal substance, including but not limited to marijuana. Then Twee will forfeit that visitation until such time that a clean hair follicle can be provided. There's step-up access and possession. First phase, 3-hour visits each Saturday from 12 p.m. ending around 3 will be supervised by paternal grandmother Rose Gillian or by any party designated by Mr. De Leon. This visitation will be for 12 consecutive weeks. Must complete this steps in this phase before access to the following steps. Phase 2 would be unsupervised visitations for 3 hours. She would have unsupervised visitations on a Saturday from 12 ending at 3 or 12 p.m. ending at 3 p.m. This will also be for 12 consecutive weeks. She must complete these step-ups before going to phase 3. That would be phase 3 would be unsupervised visits, one overnight visit a week plus 3-hour visit every other week. She'll have overnight visitations weekly on Fridays beginning at 6 p.m. until Saturday at 6 p.m. Then every other week on Wednesdays, she would have unsupervised visits for 3 hours beginning at 5 p.m. ending at 8 p.m. She must complete the 12 consecutive weeks on that to go to step 4. Step 4 would then start with weekend visits. She shall have unsupervised visitation every other weekend, beginning on Friday at 6 p.m., ending at Sunday at 6 p.m. for a total of 8 visits. In addition, she'll have visitation every other week on Wednesday, beginning at 5 p.m., ending at 8 p.m. These will take place on the non-weekend visit weeks. She'll have to do that for 8 consecutive weekend visits. After that, if mom completes all of those phases, then it would go to a standard visitation order. In the event, so as far as completing in the consecutive weeks, she must complete those unless there is a valid reason for missing those weeks due to a medical or otherwise unavoidable emergency or circumstance. If one of those issues happens, she is able to start the visits back where that ended without having to go back to repeat the steps. Child support would be set at minimum wage. Guidelines set forth by the Texas Family Code. Health insurance is currently provided by Medicaid. Department would be dismissed out. Any and all court-appointed attorneys, including ad litem, would be dismissed out upon signing of the final order. And that is the MSA year.
All right, then, Ms. No, since Mr. Novak isn't here, I know he's signed off on it and everything, but is that your understanding of this agreement? Okay, I think you're saying yes, ma'am. Can you unmute just so the court reporter can hear you?
Yes, ma'am.
Okay, very good. All right, and Ms. Riley?
That is our agreement, Judge.
All right, thank you. And Ms. Zavala?
Your Honor, that's my agreement as well, and I do believe it's in Lucas's best interest.
Okay, very good. All right, then, I'll adopt the MSA, and when a final order is submitted, I will sign that as long as it's in conformance with the MSA. And I will dismiss the department and all court-appointed attorneys from the case at that time. I appreciate your all's hard work in this, and thank you again for your patience this morning. So you all are free to go at this time. I'll look for the order.
Thank you, Your Honor. And
Thank you, Judge.
and Your Honor, on those, the contents of the MSA will be incorporated into the final order, but I'll also attach the MSA to the final order when it is presented.
Perfect. Great. All right, and that can just be attorney signature only on the final order.
Yes, ma'am.
Okay, very good. Thank you all.
Thank you, Your Honor.
All right, cause number 96568D, in the interest of Aiden Ramos and Aviana Villa. We're here for a review hearing. We are conducting this through Zoom. We're live streaming, and Ms. Taylor's making our record. All right, then, take announcements.
Daniel Trout for the department. Stacy Brown is the supervisor and will be standing in for testimony today, Your Honor. We're present, ready.
Stacy Zavala on behalf of the children with just one small request to address.
Okay. All right, then, Ms. Brown, I've looked over the report, so anything new since then?
There really isn't anything new that I've been informed of. I do want to say that the family is working with Leanne Lefevre for preparation for adoption, which makes me hopeful for these kiddos.
Absolutely.
One thing that I did forget to mention, though, is that we are in the process of, we have requested Aiden's delayed birth certificate. There's been a couple hiccups, but the application has been sent, and hopefully it won't be too long till we get that.
Okay, that was my only real question today.
Yeah, it's unfortunate. Yeah, it's so difficult to, there's so many requirements in it. I feel like those get kicked back all the time. So it has been resent again.
For the life of me, I don't understand why those are so difficult and why it's so hard, and
I don't either.
Why sworn affidavits or things like, you know, I mean, I just don't get why it's so difficult, but anyway. The world in which we live. Okay. All right, Ms. Zavala, what's the question or concern?
So everything is absolutely great with them. These are some of my Dr. Seuss kids, meaning I've seen them over there, I've seen them over here, I've seen them in a box, I've seen them with a fox. I mean, they have gone through a lot, and they have been at lots of different placements, and not through any fault of St. Francis or themselves. This placement is going wonderfully for them. Now, there is just an overall pressure once we get children in a possible adoptive home to be just laser focused on getting that adoption done as quickly as possible. I think this family is doing everything they can to make sure that this adoption is successful. They are working with Leanne, they're doing family counseling. It's really helping. I mean, these kids are doing really good, but it's very important that the kids have buy-in. I think they're going to, absolutely. I mean, there's really good stuff. I just am asking that maybe we just all kind of back off on the intense pressure of getting that adoption done right away. That's what they're moving for. That's what we're all moving for. And it is absolutely going the right way. I don't think by any means, I don't think anybody is telling this family, hey, if y'all don't adopt right now, we're going to move them. But I think sometimes those conversations can feel that way, and I don't think there's any intent for that at all. So I just want to make sure there's an order in place that they not be moved unless there's an agreement or a court order. I think we're going exactly where we need to with this case. It just may take just a smidge longer than some adoptions take. And considering their history and how many different placements they've been in, I feel like we're moving at a very timely rate with them.
Okay. Fair enough.
And
I mean,
that's
I know we always want to get to the finish line. There's no question about that, but you know, all kids are different. So, I'm happy there with Leanne. I mean, there's nobody better qualified to get them to the finish line, you know, in the most efficient way possible.
that funding for adoption support is just critical, and she's doing some great work with this family and some other families. And just the difference in these kids is just amazing, and they're really doing great.
Okay. Well, I know we all have those, you know, statistics. We have to worry about permanency and all that, but you know, it does no good to rush it, and then it all unravels, you know, and then we're right back to the drawing board. So no, I'm fine. I want the children to be excited about it and, you know, wanting it, and of course I want the family to have time to make sure they've got everything in place they need, and so I'm fine with it.
But it made me really happy to see them.
Okay, great. Okay, and we're waiting on a birth certificate anyway.
So maybe it's an advantage this time.
Yeah, maybe, I don't know.
Because we can't move forward without it.
Yeah, we're stuck in a holding pattern until then anyway. So, okay, continue the department as permanent managing conservator, continue placement. No change in placement unless there's an agreement or further court order. And I'll see you back April 2nd, 2026, 9 o'clock docket. Unless it's ready to go before then. If it is, great.
Sounds good.
If it's not, then we'll get together in April and talk about it. All right. Okay, thank you all so much. Sorry for the frenetic pace today. I don't know how else to describe it. Frenetic. Okay. See y'all next time.
Yes, ma'am. Thank you.
Okay. This is in the interest of Aaron Gomez, Kaylee Sheffield, Sierra Morales, and Maisie Sheffield. I think we were here today kind of for limited purposes on a modification that doesn't necessarily involve all of the children, but they are in the cause number. So, okay, we are here for a final hearing in that regard. And we are conducting this through Zoom under a finding of good cause and agreement of the parties. We are live streaming, and Ms. Taylor's making our record. Okay, we'll go ahead and take announcements.
Good afternoon, Your Honor, Counsel Gene Graff and Shay Cairns on behalf of St. Francis, present and ready to proceed.
Aaron Mullen, attorney ad litem for the child ready, Your Honor, or children, but specifically Aaron today.
And Ms. Grant is present on behalf of the alleged father, Martin Gomez Alvarez.
Thank you, Judge. Sorry about that.
Okay. All right, and CASA is also present with us today. Ms. Hall, Ms. Monzingo. All right then, Mr. Graff, who's gonna be our first and maybe only witness? I don't know.
Yeah, the only witness I have this afternoon, Judge, is Ms. Cairns, and I'll try and be as brief as possible because, as Your Honor indicated, it's a kind of a narrow issue today.
Okay. All right, Ms. Cairns, if you will, please raise your right hand for me. You solemnly swear or affirm the testimony you'll give today will be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay.
And Judge, before I start testimony, I would just move to offer petitioners exhibits 1 through 5. I've got the petition to modify the original order of termination, the order affirming termination, the order of substitute service by posting, and the amended paternity registry search that I would move to admit at this time.
I have no objection.
I have no objection.
Okay, thank you.
All right, then petitioners exhibits 1 through 5 will be admitted.
Okay, thank you, Judge. Ms. Cairns, if you could just state for the record your current position with St. Francis Ministries.
I'm a permanency specialist.
Okay, and how long have you been employed with St. Francis?
A little over 3 years.
Okay, and what are your primary duties as a permanency specialist?
I work with the families and children to hopefully mitigate reasons for removal, and then support the children afterwards.
Okay, and what is your training and experience?
We have several trainings that we go through to help the parents, anything that they need.
Okay.
Sorry.
Are you familiar with the case involving Aaron Gomez and his father, Martin Gomez Alvarez?
I am.
Okay, and how's that?
I've been their caseworker since the beginning.
Okay, and that's 2024. Is that right?
2023.
2023. Okay. And once you were assigned, how often did you review the child's case file and circumstances?
I would look for the parents monthly, see the kids and the parents that I was able to monthly as well.
Okay, and you were responsible for ensuring compliance with, in this case, Aaron's permanency plan?
Yes, sir.
Okay, and his mother's rights were previously terminated, is that right?
Yes, they were.
And was that April 25th, 2024? Does that sound right?
Yes.
Okay, and were the rights of a Mr. Martin Gomez and an unknown father also terminated at that time?
They were.
Okay, and has the mother's termination of parental rights been affirmed upon appeal?
Yes, sir.
Okay. Did you discover at some point that a different man was listed on Aaron's birth certificate?
I did.
Okay, and who was that?
Martin Gomez Alvarez.
Okay, and did you file the petition to modify the prior termination order in this case?
I did.
Okay. What efforts have you made to determine Mr. Gomez Alvarez's whereabouts?
We've ran accurate searches. I've done, social media, TDCJ. I've asked their mom, which she's not the most cooperative, but I've asked around family that I could. I haven't been able to find him.
Okay, and you set forth those efforts in the affidavit attached to the petition to modify, as well as the affidavit for substitute service. Is that correct?
Yes, sir.
Okay. And so at this point in time, your efforts to locate him have been unsuccessful. So is that what your testimony is? Okay. Has he ever appeared, contacted you, or sought to have contact with Aaron, to your knowledge?
No.
Does Aaron have a relationship with him?
No.
Okay. Had he appeared, would St. Francis have made reasonable efforts to assist him in potential reunification with Aaron?
He did not.
But had he, would you have made reasonable efforts to assist him in potential reunification?
Yes.
Okay. How is Aaron doing right now?
He's doing great. He's in his adoptive home right now. We're just waiting. It's just a waiting game.
And is he placed?
He's doing great.
Great. Is he placed with any siblings?
Yes, Kaylee.
Okay. And is this the same placement he's had throughout the case?
He moved there in March.
March of this year?
Yes.
Okay. Does he have any special needs?
No, he does not.
Okay. And you would say that his current placement is meeting his ordinary needs?
Yes, sir.
And he's bonded with them?
Very much.
Okay. And this is an adoptive placement, is it not?
It is.
Okay. So based on your involvement in the case, do you believe that termination of parental rights of Mr. Martin Gomez Alvarez are in Aaron's best interest at this time?
I do.
Why is that?
He hasn't had contact with Aaron most of his life that I know of. We haven't been able to find him just by Gomez. I haven't been able to find him by Gomez Alvarez or anything. He hasn't came forward. I mean, I just think it's time for Aaron to get to move forward in his life.
Okay. And what risks would he face if the parental rights were not terminated?
Well, I'm not sure what, Martin Gomez is doing right now, so could be anything.
Okay. Is Aaron old enough to express any wishes regarding permanency?
He is.
And has he expressed those wishes to you?
Yes, he's ready to be adopted and ready to move on, close this chapter.
Okay, and it sounds like with the termination, if the court were to grant termination, then he will be able to move forward and basically be in a permanent home.
Yes, sir.
Okay, and we've already identified the adoptive placement. Would you say that adoption with his sister by his current foster parents ensure his long-term stability and well-being?
Yes.
Is there anything else you believe the court should know about his circumstances?
No, he's doing great.
Okay. And in your professional opinion, do you believe termination of Mr. Gomez Alvarez's parental rights is in Aaron's best interest?
I do.
Okay. And are you satisfied that St. Francis has made all reasonable efforts necessary towards reunification and permanency in this case?
Yes.
Okay. Thank you. Pass the witness.
Just, I'm sure that I know the answer, but I don't have all that in front of me. Have we done paternity registry search in the case?
We did, Judge. We filed an amended paternity search as one of the exhibits, and it indicated no hits.
Which exhibit was that?
That was exhibit 1, 2, 3. It was the last number 5.
5. Okay. I'm sorry. I just don't, I'm not looking at them, so I couldn't remember what number was what. Thank you.
You're welcome.
Okay. Ms. Grant?
I don't have any additional questions for this witness, Your Honor.
Okay. And Ms. Molnax?
Shay, whenever Kaylee and Aaron were moved to this placement, that was an adoptive placement from the beginning. Is that correct?
Yes, it was.
And the adoptive parents, they're very ready to adopt these kids, right?
Oh, yes, very much.
And so it's been kind of frustrating that we're doing this again, and we just want to get it completed so that he can be adopted. Would you agree?
Yes, ma'am. Yes, ma'am.
And you were asked if there were any concerns about what would happen if Aaron was not, or if Dad's rights were not terminated. Mm-hmm. He wouldn't have permanency, right? He wouldn't be able to be adopted at this point.
That's true.
And he's done very well in school since he's been there. Would you agree?
Yes.
And he's in some sports, right?
Yes, he's thriving over there.
No complaints about him not wanting to be there, anything like that. Would you agree?
I would agree.
And this place is a very good place that's taking very, very good care of him, correct?
They are. Yes, they are.
And if not for these parents, he would still be in a placement like Boys and Girls Ranch or wherever it was he was at before. I don't remember.
Yes.
And so you agree it's in his best interest that this happens so that he can have permanency?
Yes.
I'll pass the witness.
Mr. Groff, any further questions of this witness?
No questions, Your Honor, and St. Francis rests at this time.
Okay. All right, then, Ms. Grant, anything to present today?
I have a trouble with my unmute button. My apologies. Nothing to present. I'll rest, Judge.
Okay. All right, Ms. Molnax.
Your Honor, I have no witnesses. I do believe that that Aaron is in a safe and appropriate environment. He is with one of his siblings. I know at least one of his other siblings has gotten to visit it and gets to have contact with him. He's doing very well in that placement. They are very eager to adopt him and his sister. I think that that's an appropriate thing, and I think it would be in his best interest for his father's rights to be terminated and for him to be able to be adopted.
Okay, thank you. And in CASA?
We agree with Ms. Mullinax. We visited Aaron in the home last month, and he is absolutely thriving. He loves his school, he loves his family. He showed us all around the house, his room, their dogs, and he's just absolutely thriving from where he was 2 years ago. So we recommend termination, and so the family can move forward with their adoption.
All right, sounds good. And as always, thanks to CASA for your all's efforts and your dedication to these kids, not just Aaron, but to all the kids. So we appreciate you. All right, everybody close.
Yes, ma'am.
Close.
All right, at this time, then I do find by clear and convincing evidence that it is in the best interest of the child, Aaron Gomez, to terminate the parental rights between the child and the alleged father, Martin Gomez Alvarez, if any. That would be pursuant to Texas Family Code 161.002, subsection B2 is failure to register with the paternity registry. I will name the Department of Family and Protective Services as the permanent managing conservator of Aaron. And at this time, I'll dismiss Ms. Grant from her representation of Mr. Gomez Alvarez. I will continue to leave Ms. Mullinax on as Aaron's attorney and guardian ad litem. And CASA, still want to stay on the case through adoption? Okay, lots of yes, shaking heads.
Yes, ma'am.
Okay. Okay, so we'll leave CASA in the case, and our next review hearing for those still involved will be, believe it or not, October 22nd of 2025, right around the corner. At that same time, just to remind everybody, we'll have extended foster care review on Maisie, and then we have subsequent hearings on March 25th of 2026. Just if you really want to do some advanced planning on your calendars.
Excuse me, Judge Baker, I'm sorry.
Yeah, that's okay.
Maisie
I'm
is
the better half, as long as
I
you
know, it's been a long day, ma'am.
It has been.
Maisie is in trial independence, and the last order you signed said there would be no further hearings until she returned to care.
Okay. I just had that we had them scheduled, but I just have to go back and look at it, but hang on real quick, let me look. We met, and that's probably correct. Let me look real quick. Well,
it was 8/20 of 25. There was an order to dismiss conservatorship. And it says the trial independence period would end on December 31st. And that no further hearings unless young adult returns to care.
Okay. All right, yeah, I guess because we got court reports on. I just was on her, I was thinking we were gonna do another hearing, but no. So just strike that, there won't be a hearing on Maisie then.
And Judge, since you went ahead and told us the March 25th date, I'm just gonna tell you right now, I have a week-long jury trial that week in Randall County too, that's specially set, so I'm not gonna be able to do that date.
Okay, it's a review, so, maybe somebody can cover.
Yeah, I put it on there, and that way if something comes up later, I can try to get somebody or we can figure out a different day. I just thought I'd let you know ahead of time.
Okay,
And we
Yeah,
can send out a proposed order in advance too.
sure, that's a possibility. And, you know, by then your jury trial, who knows what will have happened with that.
Oh, well, they've been requesting it for about 1.5 years, so I think that one's gonna go.
All right, well, we will cross the bridge when we come to it and figure it out.
Okay.
Okay, all right, I sure appreciate it. Thank you all very much. Amy, thank you.
Thanks, y'all.
And those
Ma'am,
of you
thank
that
you.
were, those
Thank you.
of you that were around this morning, I'm sorry it was such a wild day, but we got through it.
This is why we get paid the big bucks, Judge.
That's so true. Yeah, that's it.
It's
Well,
wild. And we've been working them behind the scenes too. After we got done with you, our emails have been nuts today.
yeah. Yeah, it's been a busy one, but it's just about over. So everybody have a great weekend. If I don't see any of you.